I seek your lordship indulgence in mentioning part 2, item number 12, with the consent of the parties, if the matter may be listed after 2 weeks.
Item number
12.
12.
Yes.
At the request of the learned counsel for the parties, list this matter again after 2 weeks.
Obliged.
May I seek your lordship indulgence in mentioning part 2, item number 15, lordship.
Huh?
I have taken the consent, and if the matter can be kindly taken up on the 20th week of April.
28th.
20th, immediately after the vacation that
Okay.
week.
At the request of the learned counsel for the parties, list this matter in the week commencing 20 April 2026.
Yes, lordship. Deeply obliged.
Daily list for admission, item 1.
Yes, sir.
Lordship, this is the criminal appeal,
Huh?
and this criminal appeal is against the judgment and order dated 25/1/2024,
Huh?
passed by the learned CJM Champai. And this is a foreign cigarettes case, and 3 accused were booked under the 135 of the Customs Act. So after taking all the evidence, then the learned CJM had acquitted all the accused. So we came before the Lordship challenging the judgment and order, Lordship. And
What is your ground?
Lordship, I have
There are no independent witnesses during the arrest. These cigarettes have not been said to be foreign. You did not have any proof to say that they are foreign cigarettes.
yes, that is the findings of the learned CJM, and the other finding is that we have not done the inventory before the judicial magistrate. However, Lordship, cigarette is the notified goods under 123 of the Customs Act. So under the 23 of the Customs Act, there is a reverse burden of proof. So from whom we have seized, they have to show that this is not a smuggled goods.
First thing is that where is that proof that you have seized it from them?
Lordship, that earlier it was detained by the Assam Rifles personals, and they have handed over to the Customs Department.
We'll catch anybody and hand it over to the Customs Department and he'll say that
They-
yes.
They have handed over to the Customs Department, then we have prosecuted accordingly, Lordship.
No civilian witnesses when the Assam Rifles handed over the seized good to you. Forget it at the time of the seizure. Even when they were handed over to you, even then there were no civilian. Anyway, issue notice. I heard Mr. Solicitor Counsel appearing for the appellants. This is 3 persons were there. You have filed it against 1.
Lordship, 3 persons, but the respondent number 1 died, and I have submitted the affidavit to that effect
Okay.
on 6/8/2025. And respondent number 3 is not able to trace his address, so we have published in the newspaper.
No, there were 3 accused.
There are 3 accused. Then one is
Lale
Lal
Denthara.
Edenthera died on 21/6/2021.
But have you seen the criminal appeal? On the first page, it is only Lale Denthara.
No, Lordship.
Eh? Am I wrong?
There are 3 accused, Lordship.
No, but
In the first page is Lal Edenthera and 2 others. That's the first page. and
so
in-
Lale Denthara is. Where is your appeal?
Appeal is at Lordship.
Heard Mr. Swenson Counsel appearing for the appellant, Union of India. The learned counsel for the appellant has submitted that the respondent number 1, accused number 1 in the trial, has since expired.
Lordship, yes.
And whose address you are not being able to trace out?
Respondent number 3, Lordship.
Respondent number 3, then how? You made a statement.
Lordship, yes, I have filed the affidavit to that effect also. The affidavit is on 29/1/2026.
Nothing here. There are two files. Huh. The delay has been condoned.
Yes, already condoned, Lordship, in the last court date.
When was this thing filed?
Filed on 29/1/2026, as per my report.
9/1.
29/1/2026. As per my report, Lordship. The affidavit is regarding the newspaper publication.
Receipt of where is it? 29, yes, 2026. So even in the appeal, you have to go for paper publication.
Lordship, yes.
That was
And
only the notice in the IA.
Lordship, yes. And let the TCR may be called for. Let the appeal be admitted then.
So the respondent number 1 has expired. Hai na? The learner counsel further submits that the respondent number 2 could not be served with the notice or served a notice by usual process since her address was not confirmed.
Lordship, yes. Respondent number
He
3.
has submitted then in the interlocutory application praying for condonation of delay. The notice was served through paper publication. Good stuff. Call for the trial court records. Issue notice on the respondent number 2 and 3. The respondent number 2 under the since on the earlier occasion you'll have to take steps once.
Lordship, yes.
You'll have to take steps once at least. Issue notice on the respondent number 2 and 3 by speed court. Steps within 1 week. List again after receipt of the trial court records along with service report on
Lordship,
the
yes.
respondent number 2 and 3.
Lordship, Lordship.
Item 2.
May I please, Your Lordship?
Yes.
I'm appearing on behalf of my senior, President Hang Moya. He, due to some personal difficulties, may this matter be taken up on this 27th of this month.
At the request of the learned counsel, we paying for the petitioner. List this matter again on 27/4/2026.
Obliged.
Item 3.
Your Lordship, in this matter, may I seek for another 2 weeks' time to file rejoinder affidavit against the affidavit of position of respondent 4.
Mr. Swenson and counsel appealing for the petitioner has prayed for an accommodation for 2 weeks to file the affidavit in reply to the affidavit in opposition filed by the respondent number 4.
Yes.
They are not being objected to by the learned counsel for the respondents. The same is allowed. List again on the 4th of May, by which time the petitioner may file the response to the affidavit in opposition filed by the respondent number 4.
Much obliged.
Item 4.
May it please your lordship, I'm
Yes.
appearing on behalf of the state respondents in this contempt case, your lordship. As per my verbal instructions that I received yesterday, the payment along with interest has been done by the state respondents. However, we may be allowed to file the affidavit in compliance in a matter of 3 weeks, your lordship. The payment
The
with
order has
interest.
been complied
Yes, your
according
lordship.
to-
We'll have to see their affidavit. That computation of interest is the issue now. Some payment has come.
Huh?
Some payment has been made, my lords.
Ah.
But the issue with computation.
No, is it, okay. The learned counsel appearing for the respondents has submitted that there has been substantial compliance of the orders passed by this court in WPC 80 of 2022. She accordingly prays for an accommodation to file the compliance affidavit. Prayer not being objected to by the learned counsel appearing for the petitioner, list this matter again on when do you file?
Your Lordship, if 3 weeks may be granted, Your Lordship.
On the 4th of May,
Yes, Your Lordship.
4th of May 2026, allowing the respondents to file the compliance affidavit.
Much obliged, Your Lordship.
Obligement.
Orders, item 5.
My lord, steps were taken for the respondents on 21/1/26. However, ID card for respondents 1 and 2 is still awaited.
Who is the respondent number 1? Private party.
Private respondents, my lord.
Office note dated 9/4/2026 reflects that the AD card for service of notice upon respondent number 1 and 2 are awaited.
My lord, if the honorable court may direct the registry to check the consignment and give a report.
The registry would check the consignment track report
My lord,
and place the same before this court with a note on 23rd of April.
my lord.
23rd of April.
For hearing, item 6.
Your Lordship, yesterday I asked the Institute, Repans, to furnish all the relevant documents pertaining to the BOG meeting minute. So I have furnished to Your Lordship, and a copy was given to the petitioner's counsel.
Anything of value?
Yes, and the first page is the letter addressing to me. Page 4, I have given the page number at the top, my lord.
Yes.
Page 4 is the meeting minute. Item 3. Item number 3.
Inclusion of tutor's teaching faculty, enhancement of superannuation age to 65 years. Yes, sir.
Yes, so this is from bare reading of this. It is in fact,
So
we
now
can
they say that the teacher has become a teaching faculty and the enhancement of superannuation age to 65 years.
Yes, that is what I'm trying to say, my lord. But if I may take your lordship to the agenda proposal, that is at page 12.
Page?
12.
Yes.
This is the agenda notes. And the wording is exactly the same with the impugn order, what it
No,
has.
the agenda is
Agenda note is given here at page 12.
okay. So now there is no doubt that tutors would be teaching faculty.
Yes,
There is no doubt on that.
there is no doubt.
So 62 is certain.
So, but our stand is that,
But
my lord.
since they do not have the MSc,
Yes.
since they do not have the MSc,
Yes.
the enhancement till 65 will not come in.
Yes, but our stand is that if it may be recorded, my submission in that regard is that, my lord,
we'll
this
take it.
it has to be, the whole reading has to be made. It has to be continuously read. All the
We'll do that. We'll do that.
so
We'll do that.
since the petitioner is not a
But then,
qualified.
you also have to answer this pointed query that when the education qualification of teaching faculty is master's degree and above, and tutors were only those persons who did not have the master's degree.
Yes.
When you include them as teaching faculty, when you say tutors will now become teaching faculty,
Yes.
does it not imply that all persons with bachelor's degree are now teaching faculty?
No, that is what the agenda note. Our interpretation
Can
in
you,
the yes.
let us again reframe the question.
Yes.
All the persons who were already teaching faculty
Yes.
had a superannuation age of 62.
Right.
Others all had an age of 60.
Yes.
Now you say that those teaching faculty who have MSc will be 65. Is it?
In tutor.
No.
Tutor post.
Tutors will not have. Tutors would not have MSc, sir.
That is what, Your Lordship, if we look at the agenda note,
No, the agenda note cannot be read in the air. We have to first find out what is a tutor and what is a teaching faculty.
yes, tutor was not included under the teaching faculty.
Because the recruitment rules of the tutors itself said that you only need to be a graduate. A person with an MSc, if he applies for a tutor, that is a separate issue. But otherwise, with a bachelor's degree, you can only be a tutor. These tutors are now made teaching faculties. That is what it says.
But thereafter, tutors having the qualification of MSc nursing, they were also there. And this
They
proposal
will
is
be entitled to 65, no doubt.
yes,
They will be entitled to 65, no doubt.
yes. But inclusion of the tutor in the teaching faculty is conditional, only conditional in favor of only those MSc nursing qualified. So this is what it intends to say, my lord. Although the meeting minute had like shortly given the approval without explaining what had been written in the agenda note. But if we look at the agenda note, that is what it is intended to do. Because we have to continuously read all the, without breaking it into two parts. That is what we meant to say, my lord. This is the exact reason why he was rejected.
We will dispose it off.
Lordship, I just make a short submission. As the Lordship had earlier observed, the short question that needs to be decided is whether tutor, the post of tutor under refunds is included in the teaching post or teaching faculty. That is, that has to be answered in the positive. And the next thing is, if so, whether the petitioner was holding the post of teaching faculty. Since he is a tutor, he is a teaching faculty. So, and under the given circumstance, whether he is to retire at the age of 60 or 62. Those are the three things that needs to be decided. And by the decision of the BOG, everything has been decided in favor of the petition. So, my humble understanding of the letters, the decision, as conveyed at page 19 of this BOG letter, the last page, it is a letter addressed to the Director, Repans. It is regarding consideration of proposal for inclusion of tutors and clinical instructors of College of Nursing as teaching faculty. Regarding, here it clearly says that I am directed to refer to your letter number so and so on the subject mentioned above and to convey the approval of the Honorable Health and Family Welfare Ministry in his capacity of President of Board of Governors, Repans, ISOL, to include tutors of Repans as member of teaching faculty, in addition to the posts already identified in terms of provision 2, subclause 5 of bylaws, copy enclosed, and the age of superannuation to be enhanced to 65 years, which will be applicable to those having MSc in nursing, subject to the condition that these nurses would continue to function as faculty after the age of 60 years. Since I'm not in the nursing, a nurse, since I'm having the degree of MBBS, right from the beginning, MBBS was one of the eligible candidates. And being MBBS, I was appointed as such. And thereafter, I continued. And this 65 years is applicable only in respect of MSc nursing. I'm not aspiring for 65. But since I've been included as a teaching faculty, member of teaching faculty, the decision that has been made by the government, central government, as well as adopted by the Executive Council of these RIPANs, I am entitled to retirement at the age of 62 years. As already stated earlier, the fact that under Rule 22 of the Memorandum of the Rules, which is under Memorandum of Association, Rule 22 says that, save as otherwise prescribed, all employees of the Institute after successful completion of probation period will be offered continuous appointment up to the date of superannuation, which shall be the date of attaining the age as determined by the Government of India from time to time. That is in respect of the members of the employees working under RIPANs. And since this office order dated 6 March 2024 had implemented the decision of the Board of Governors in its meeting held on 12/12/2023. Tutor, the post of which I've been holding, of RIPANs in nursing department have been included as a member of the teaching faculty, and as to whether I should retire at the age of 60 or 62 has already been decided in the 22nd EC meeting held on 3/1/2006, as per which I have enclosed here at page 79, Your Lordship, as per which it is decided enhancement of superannuation age of teaching faculty staff up to 62 years, on par with the CHS. Superannuation age of all other staff shall remain at 60 years. Copy of the Executive Council minute is enclosed at Annexure 1, which I have enclosed here. However, the BOG, Board of Governors, in its meeting held on 12/12/2023, ratified enhancement of superannuation age of tutor to 65 years, applicable to those having MSc. This is an exception. Those having MSc nursing is an exception. Exception for the purpose of extension up to the age of 65. All others in the teaching faculty will retire at the age of 62. This is an exception. However, the BOG ratified enhancement of superannuation age of tutor to 65 years, applicable to those having MSc in nursing, subject to condition that these nurses would continue to function as faculty after the age of 60 years. Here, it is stated that copy of the BOG minute is enclosed, but that has not been enclosed. That's why we have postponed the matter till today, Your Lordship. And now, since the BOG meeting minute has been before Your Lordship, and as per the meeting minute, it is very clear that there can be no other opinion other than what has been sought to be implemented in respect of the petitioner. Because he is a member of the teaching faculty, he is to retire at the age of 62 in respect of those nursing staff having MSc nursing. It will be extended even up to 65 years. Since I'm not having MSc nursing, And since I'm in the, not in the nursing line, as MBBS, I have to continue only up to the age of 62. And Lordship, since I have been released prematurely by the impugned order on my attaining the age of 60 years, Lordship, I have left the institution there and then. And now 2 years have almost elapsed. Now that if a decision is made in favor of the petitioner, he will not be able to work in the institution, but he'll be entitled to all the benefits of service. Lordship. This is my humble prayer. So in the view of the matter, Lordship, since he is to serve, even if reinstated to service, only up to 30th of April 2026.
Okay.
He has a very short span of time. But nevertheless, since he has been ousted from service, not because of his desire, but because of the decision which is likely to be held.
Are you drawing your pension now?
No, I have not drawn. It's not a pensionable post, Your Lordship.
It's not a pension.
It's a repunch.
But the other benefits under the NPS? He's under the NPS. Is it? Oh, what is the pension scheme? After
It will
superannuation,
be
what happens?
whatever benefit that will be there, but even that I have not enjoyed. Because immediately
A
after my
simple, yes, sir.
yes, Your Lordship.
Okay, we'll record all that. Simple English. They would go and he will go. So when you use the term would, it means more than one. And when you say will, it means singleton. If you have that resolution, it says which will be applicable. So it is speaking of one condition. And that has to be read to be the condition immediately preceding that particular phrase. If it had been for both the conditions, the requirement of MSc nursing, if it had been for both the conditions, which would be applicable.
Understand.
When the term used is which will be applicable, it has to be restricted to one. That is how we are trying to find out every
Yes.
manner in which we can appreciate your argument
Yes.
to say that the phrase which will be applicable to those having MSc nursing. So this conditions will be applicable only to MSc nursing people. That is your argument.
Yes.
If we try to understand that also, the term will makes it restricted to one particular condition.
Understand, my Lord.
So
It will be the interpretation.
no, we are trying to see because this is not one case where one man will get a benefit.
Yes.
Anybody who is coming from a tutor to the faculty,
Yes.
everybody would get that benefit.
Yes, exactly.
So it will also have ramifications in the administration of the
Right.
refunds.
Right.
We understand that. But your arguments are not falling into place on the from either side. Okay, we'll dispose of it.
Yes.
I love that.
Much obliged.
Okay, take your heard, Mr. Should we dispose it of here itself?
Yes.
13012. Yes, we can dispose it of. Heard Mr. C. Lalamzova, then a senior counsel assisted by Mr. for the petitioner. And also heard Mr. B. Lalram Menga,
Yes.
Standing Counsel, Ripansu.
Yes.
I'll take some time to
It's all right,
get
Your
acquainted
Lordship.
with the-
Yes.
this thing. Good stuff. Who appears for the response? The petitioner has raised a grievance in this writ petition preferred under Article 226 of the Constitution of India against the order dated 1/4/2024 by which the respondents had informed the petitioner that the superannuation age of tutors without MSc nursing degrees being restricted to 60 years, the petitioner would stand retired on 30/4/2024 on attaining the age of 60 years. A grievance has also been raised against the order dated 24th of May 2024 by which the director of the respondent institute had informed all concerned that the petitioner was retired with effect from 30/4/2024 on superannuation. Full stop. The petitioner has also raised a grievance against the letter dated 19/6/2024, whereby he was informed that at the time of his retirement, he was a tutor within bracket non-faculty post and as per the 22nd Executive Council meeting held on 3/1/2008 and the 11th Board of Governors meeting held on 12/12/2023, it was clearly stated that the age of superannuation for non-faculty post is 60 years. It is not in dispute that the petitioner stood retired on 30/4/2024 and thereafter he had filed this writ petition on the 5th of August 2024 assailing the aforesaid orders and praying for directions to the respondents to reinstate the petitioner in his service by allowing him to continue in his post as a tutor in nursing department under the repans with all service benefit with effect from 30/4/2024 till he attains the age of superannuation at 62 years. The facts as revealed in the writ petition is that pursuant to an advertisement issued by the respondent institute, the petitioner had participated in a selection process and had been appointed to the post of tutor within bracket senior demonstrator in the scale of pay as applicable at that point of time with other allowances admissible under the rules from time to time with effect from the date of joining duty. the services of the petitioner was officially attached to the Department of MLT through the order dated 3rd of September 2013 with immediate effect. Full stop. What is this Department of MLT? Laboratory technicians. Okay.
I'm not sure, Your Lordship. but I
Medical
can check it.
laboratory technology, Your Lordship. Medical laboratory technology.
You write medical laboratory technology within bracket MLT. Huh? See. At the time of the petitioner joining his services, the relevant recruitment rules for the post of tutor was an MBBS degree or BSc in nursing or graduation with postgraduate diploma in public health / preventive medicine / nutrition / home science. Stop. The petitioner is and holds the degree of MBBS and the same is not in dispute. Stop. Where is it? 33312026. Enhancement 312026.
79, 2006. 79.
Page 79, Lordship. It says 6 June 2024.
No, I want
It's,
30. Do we have a copy of the 312026 anywhere in the affidavit or anywhere?
Let's see, 3/1/2006. Yes, at page 83, a lot.
Page 80.
83. Type copy is at page 84. Yes, extra copy of 22nd EC meeting.
By a resolution adopted on the 22nd Executive Council meeting of the Institute in the meeting held on 3/1/2006, the decision was taken to approve to enhance the age of superannuation of teaching staff up to 62 years on par with the CHS. Full stop. The age of superannuation for all other staff was to remain at 60 years. Stop. By an office order dated 6th of March 2024, the director of the institute had in continuation of an earlier office order dated 16/6/2022, and in pursuance of the approval of the Honorable HFM in his capacity of President of the Board of Governors, Ripans, Aizol, and don't write the word end, as ratified by the Board of Governors in its 11th meeting held on 12/12/2023, notified to all concerned that tutors of Ripans in nursing department have been included as inverted comma member of teaching faculty inverted comma close in addition to the posts already identified in terms of provision numerical 2 within bracket numerical 5 of bylaws of Ripans, and the age of superannuation has been enhanced to 65 years, which will be applicable to those having MSc in nursing subject, subject to the condition that these nurses would continue to function as faculty after the age of 60 years. Full stop. Such tutors, if interested to continue to function as faculty beyond 60 years of age, may submit such willingness to the office in due course of time. May submit jahan pe likha hai, where you said may submit, please change it. You said were required to submit such willingness. Huh? Okay. Now just a minute, don't write. This at page 72. At page 72, in the year 2022, you were told that you would retire in 2022. Why?
These are lots of two other seniors of the petitioners.
Or this is not the petitioner?
This is not the petitioner. This is only cited as precedent. Dr. Lalsang Luralte and Dr. Rini Larinjwali. They were in the teaching faculty. They retired on attaining the age of 62.
Okay, we'll come back to that. On an inquiry raised by the petitioner, the director of the institute, by a letter dated 1st of April 2025, informed the petitioner that the superannuation age of 65 years has been enhanced only to tutors having MSc in nursing subject to the condition that these nurses would continue to function as faculty after the age of 60 years. The director further informed the petitioner that the superannuation age of tutors without having MSc nursing degree was 60 years, and therefore the age of the petitioner for superannuation would stand at 60 years as on 30/4/2024. The petitioner thereafter preferred a representation on 22/4/2024. Full stop. By the office order dated 24th May of 2024, all concerned in the institute were informed that the petitioner stood retired with effect from 30/4/2024 on attaining the age of superannuation. The petitioner had thereafter submitted another representation claiming that the age of superannuation, with regard to him was required to be 62 years, if not 65 years, full stop, by the order dated, by the communication dated 19th of June 2024. The petitioner was informed by referring to his representation that at the time of his retirement, the post of tutor was a non-faculty post, and in view of the 22nd Executive Council meeting held on 3/1/2008 and the 11th Board of Governors meeting held on 12/12/2023, the age of superannuation for non-faculty post was 60 years, full stop. It is at that point of time that the petitioner approached this court, challenging the orders as noted above and praying for appropriate relief of reinstatement and for being allowed to serve the institute till the date of attaining the age of 62 years. Full stop. Mr. Lalram Zuava, learned senior counsel appearing for the petitioner, has submitted that the service conditions of the persons working in the RIPANS, in the Regional Institute of Paramedical and Nursing Sciences, within bracket RIPANS, Aizawl, Mizoram, are governed by the rules and regulations of the institution, full stop, drawing attention of this court to the contents of provision 22 of the aforesaid rules and regulations, the learned senior counsel has submitted that, save as otherwise provided, all employees of the institute would be offered continuous appointment on successful completion of probationary period up to the date of superannuation, which shall be the date of attaining the age as determined by the Government of India from time to time. The learned counsel for the petitioner has thereafter referred to the bylaws of the RIPANS to submit that, as per bylaw 2 within bracket 5, member of a teaching faculty would mean professors, readers, assistant professors, selection grade lecturers, senior grade lecturers, and lecturers, full stop. The learned senior counsel has thereafter referred to the advertisement number 1 of 1997, in response to which the petitioner had been appointed, to indicate that the petitioner had applied for the post of tutor since he had the qualification of MBBS, full stop. The learned senior counsel has submitted that persons with MBBS or BSc nursing or graduate with postgraduate diploma in public health, preventive medicine, nutrition, home science were eligible to apply for the aforesaid post. Full stop. How do we say this is a non-faculty post? Because it is the post of a tutor. The learned senior counsel has submitted that since the post of tutor was not one of the posts included in the definition of members of the teaching faculty, the post of tutor has to be necessarily be held to be a non-faculty post at the time when it was advertised and the petitioner had participated and was selected and appointed to the aforesaid post. The learned senior counsel for the petitioner has thereafter submitted that in view of that the Executive Council of the Institute in its meeting held on 3/1/2006 had approved to enhance the superannuation age of teaching faculty up to 62 years on par with the CHS, full stop. The learned senior counsel has submitted that the respondents have not disputed the aforesaid position that members of a teaching staff were allowed to serve up to 62 years, which was the superannuation age at that relevant point of time at par with the persons serving in the Central Health Services within bracket CHS. The learned senior counsel has referred to Annexure 10 of the writ petition, which is an order dated 28th of February 2022, by which two of the teaching staff, a teaching faculty in the institute, were allowed to serve up to the till the time they attained the age of 62 years. Full stop. The learned senior counsel has submitted that therefore there can be no dispute that teaching faculty in the institute would remain in service till attaining the age of 62 years. The learned senior counsel has thereafter drawn attention of this court to the information provided to, this information was provided to you or to whom? Is it to someone else?
This RTI information.
At page 79?
This was on the basis of an application made by Ms. Larin Kimi, who is the niece of the petitioner.
The learned senior counsel for the petitioner has thereafter referred to the information supplied by the institute to the niece of the petitioner on 6th of June 2024 in reply to an application filed under the Right to Information Act 2005, whereby it was informed that the '22nd Executive Council meeting held on 3/1/2006 had decided the enhancement of superannuation age of teaching faculty up to 62 years at par with the CHS. The aforesaid document had also informed that the superannuation age of all other staff stood at 60 years. The information also divulged was that the Board of Governors in its meeting held on 12/12/2023 had ratified the enhancement of superannuation age of tutor to 65 years applicable to those having MSc in nursing having MSc in nursing, subject to the condition that the nurses would continue to function as faculty after the age of 60 years first. The learned senior counsel for the petitioner has submitted that the 11th meeting of the Board of Governors held on 12/12/2023 had ratified two resolutions. First, that the members of the tutors of RIPANS in nursing department would be included as a member of teaching faculty in addition to the posts already identified in terms of provision 2 within bracket 5 of bylaws of RIPANS. And secondly, that the age of superannuation had been enhanced to 65 years, which will be applicable to those having MSc in nursing, subject to the condition that these nurses would continue to function as faculty after the age of 60 years. Full stop. The learned senior counsel has submitted that once the tutors of RIPANS in nursing department had been included as members of teaching faculty, the date of superannuation of 62 years, which was adopted in the second EC meeting held on 3/1/2006, enhancing the age of superannuation of teaching faculty up to 62 years at par with the CHS, would also apply to the case of the petitioner, and he would be entitled to serve the institute up to the age of 62 years. The learned senior counsel has submitted that the petitioner not having a master's degree, a master's in MSc in nursing at the time of his appointment, or even at the time, even at a later stage, he may not be entitled to the enhancement of the age of superannuation to 65 years, but given the inclusion of the tutors of the RIPANS as members of faculty, he cannot be denied the advantage of having his age of superannuation elevated to 62 years instead of 60 years, full stop. The learned senior counsel has submitted that in view of the aforesaid, the present writ petition deserves to be allowed by this court by setting aside and quashing the orders dated 1/4/2024, 24/5/2024, and 19th of June 2024. The learned senior counsel has submitted that the petitioner in any event would attain the age of superannuation on the 30th of April 2026. Change the sentence to like this. The learned senior counsel has submitted that the petitioner would attain the age of superannuation of 62 years on 30/4/2026 in the event this court holds that the age of superannuation in relation to tutors in the repanse stood enhanced to 62 years on by the resolution adopted by the Board of Governors in its meeting held on 12/12/2023. The learned senior counsel has submitted that since the petitioner has been illegally deprived of serving the institute for the past 2 years, the petitioner would also be entitled to consequential relief in accordance with law. Mr. Lalra Menga, learned standing counsel for the Repans, has opposed the prayers made by the petitioner in the writ petition by submitting that the petitioner had undoubtedly joined his services as a tutor in the institute by having an MBBS degree, and it is an admitted position that the petitioner does not possess the qualification of MSc in nursing. The learned counsel for the institute has submitted that the petitioner has sought to interpret the resolution adopted by the Board of Governors in its 11 meeting held on 12/12/2023 to his own advantage, full stop. The learned counsel has submitted that the tutors of Repans in nursing department have been included as member of the teaching faculty, and the age of superannuation has been enhanced to 65 years in respect of only those tutors then what about the persons who were already teaching stuff? If we read it the way you want us to read it, another difficulty comes in.
My submission
If
is
this is only for tutors who now come in with that MSc nursing and
Yes.
become teaching faculty, what happens to the other teaching faculty which was already there?
no, Your Lordship. This
Teaching
includes,
faculty, has it been made 65 by any other resolution?
no, this is the only resolution.
So, persons who were already working, if we take this, which will be applicable to MSc nursing personnel, to be applicable to tutors of Repans who have now become member of teaching faculty, Then what happens to the teaching faculty which was already there?
No, tutor was,
Their age is not raised.
it was included by BOG meeting 2023 only. Tutor post was included as teaching faculty member. But it was conditional. The conditional only those tutors having the qualification of MSc nursing
Would become.
would become the teaching faculty. That is.
What is the last line we said? Only those service holders who had an MSc in nursing subject in MSc, who had an MSc in nursing subject to the condition that those nurses would continue to function as faculty after the age of 60 years. In other words, the Learned Council for the Institute has submitted that only those tutors of repans who had the qualification, who held the qualification of MSc in nursing would stand to be benefited by the inclusion as member of teaching faculty, and only those members who would come in as members of teaching faculty with the qualification of MSc in nursing would be entitled to an enhanced superannuation age of 65 years. That is your submission? The Learned Council for the Institute has submitted that the petitioner did not have the qualification of MSc in nursing, and therefore he would not be a tutor who could be included in the definition of member of teaching faculty, and in the absence of such an inclusion, the petitioner, the age of superannuation of the petitioner, being a non-faculty member of the institute, would stand at 60 years. The Learned Council for the petitioner has submitted that in view of the above, there is no error committed by the institute in fixing the age of the petitioner for superannuation at 60 years and in releasing the petitioner on retirement on 34/2024, which is admittedly the date on which the petitioner attained the age of 60 years. He has accordingly prayed for dismissal of the writ petition. It would not. It would be relevant to mention here that on a request made by this, on this court requiring to, it is relevant to mention here that the Learned Council for the Institute had produced the relevant minutes of the meeting of the 11th Board of Governors held on 12/12/2023, as well as the agenda which was placed before the aforesaid board with regard to the inclusion of the name of the inclusion of tutors of repans as member of teaching faculty, and the age of superannuation to be enhanced to 65 years, which will be applicable to those having MSc in nursing subject to the condition that the nurses would continue to function as faculty after the age of 16 years.
Your Lordship, sorry for interruption, my Lord. In my submission, it may kindly be added, one of my submissions was that this approval order by the BOG has to be read as a whole without breaking it into two parts.
Before you say that he has accordingly prayed for dismissal of the petition, I have said, no? Just before that, here, the Learned Council for the Institute has submitted that the approval granted by the BOG has to be read as a whole, continuously, without breaking the sentence into two parts, comma, whereby one, the tutors serving in the repans could be included as member of teaching faculty, and the age of superannuation to be enhanced to 65 years only for those tutors who had a qualification of MSc in nursing.
Yes.
We'll modify that sentence to do that. We just modify that sentence. In reply, the Learned Senior Counsel appearing for the petition has submitted that in view of the undisputed fact that members of the teaching faculty would be entitled to a superannuation age of 62 years, comma, that the tutors of the repans had been included and the member of teaching faculty by a resolution taken by the Board of Governors, comma, there can be no dispute that the petitioner, who was earlier a tutor, within bracket non-faculty, was required to have been included as a member of teaching faculty, and since the age of the superannuation age of teaching faculty had already been raised to 62 years by the Executive Council in its meeting held on 3/1/2006, the petitioner would be entitled to retire on 34/2026 and not on 34/2024. The Learned Council has submitted that the clause for enhancement of 65 years as the age of superannuation would apply to only those teaching faculty who had MSc in nursing and not to other members of the teaching faculty who did not have MSc in nursing, full stop. Since the petitioner did not have the masters in nursing, comma, he would remain entitled only to the enhanced age of 62 years for superannuation. I have heard the Learned Counsel for the petitioner. Now, for the contesting party, I have heard the counsels appearing for the contesting parties, comma, gone through the contents of the writ petition, comma, the affidavit opposition, and the, have you filed an affidavit in reply? And the affidavit in reply filed by the petitioner. The fact of the petitioner having participated in a selection process and thereafter of being appointed as a tutor within bracket non-faculty in the repans remain undisputed. The fact that the age of the teaching faculty had been enhanced to 62 years for superannuation from service also remains undisputed. The only dispute that requires the attention of this court for adjudication of the issues is as to whether the resolution adopted by the Board of Governors, the resolution adopted by the 11th Board of Governors in its meeting held on 12/12/20, what was the date?
2023.
12/12/2023.
Yes.
Has to be read to be restricted to only those tutors who carried a master's degree in nursing, or whether the said resolution would cover all tutors in repans to be converted to members of, to be included in the definition of members of faculty, and the requirement of an master's degree in nursing would only be applicable to those, would be applicable only in order to give an incumbent the benefit of enhancement of this age of superannuation to 65 years, subject to the condition that the said incumbent would continue as a member of the faculty after attaining the age of 60 years.
Lordship,
Yes?
since we have not made a reference to the affidavit in the reply, what we have stated in the affidavit in reply, paragraph 14, may be perused, Your Lordship, where we have stated that it may be further stated that those tutors in nursing department having degree of BSc nursing would be eligible for consideration of the enhanced superannuation age to 65 years only if they are having degree of MSc nursing. And the same has no application in respect of other members of the teaching faculty.
And that is what we have all discussed. That is
Yes,
what we
yes.
are all trying to find out.
Since we have met a specific statement to that effect, Lordship.
We have recorded it as a part of your argument. Because otherwise we'll be replicating the pleadings only all the time. So we have taken it up as your statement, and this what is this? The agenda note for the 11th meeting of the Board of Governors of Repans has been placed before this court by the Learned Counsel for the Institute. Although it is not in the form of an affidavit, since the same does not require a controversial, the same is taken on record with the consent from the Learned Counsel for the Learned Senior Counsel for the petition. The item number 3 of the aforesaid agenda is quoted below. Ministers, you'll find it at page 12. I'll mark on this. The resolution with regard to the aforesaid item number 3 is adopted by the Board of Governors is also reproduced herein below for easy reference. For easy reference, this will be by the blue flag, at page 4. I have ticked it up by the pencil, The letter dated 25/4/2022 referred to in the aforesaid agenda is a part of the writ petition filed by the petitioner. It's that letter.
Page
25/4.
Page 19 of the resolution, which has been submitted by the Learned Council. Last page.
Which has been made available by the Learned Council appearing for the Institute, is also quoted herein below for a ready reference. This is page 19, green flag. A perusal of the letter dated 25/4/2022, the agenda placed before the Board of Governors during its meeting held on 12/12/2023, and the resolution adopted by the Board of Governors indicate the intention to include tutors of RIPANS as members of teaching faculty. Full stop. The petitioner, being a member, being a tutor in the RIPANS, at the first glance appears to be a person entitled to be included in the definition of included within the definition of the members of teaching faculty of the institute. The difficulty arises due to the interpretation sought to be given by the institute that for inclusion of tutors in RIPANS as members of teaching faculty, it would be necessary for the incumbent to have a master's in science degree in nursing subject. This court has noticed that the relevant educational qualification for appointment of a person as a tutor in the institute was a graduation degree, be it MBBS or a BSc in nursing. Where is that? BSc in nursing, or a graduate with postgraduate diploma. Although the although the recruitment rules containing the relevant educational qualification required for appointment to the post of or to the different posts in the institute had not been placed before this court, comma, a perusal of the advertisement number 1 of 1997 would indicate that for being considered to the post of lecturer, comma, senior tutors, lecturers and senior tutors, comma, the minimum educational qualification required was a master's degree in the particular field. While, as already noted above, the requirement for a tutor was only a graduate degree. The intent of the letter dated 25/4/2022 was to include the tutors in the institute within the definition of member of teaching faculty. There is no doubt that a person who carried a master's degree in nursing would already stand appointed or recruited as a teaching faculty in the institute if he had so applied for the post. And full stop. However, comma, as submitted by the learned counsel for the respondent, comma, there may have been candidates or there may have been incumbents who were holding the post of a tutor in the institute but yet held a master's degree in nursing. When the intent of the letter dated 25/4/2022 was to give an opportunity and was to include tutors in the definition of members of faculty, comma, there does not appear to be any qualification of the tutors requiring to hold the degree of masters in nursing to be incorporated. This is so because even on a simple grammatical, even on appreciation of the simple, even on a simple appreciation of the language used, comma, it would be reflected that the word used in the word will has been used in the letter that the sentence this is so because a plain reading of the contents of the letter dated 25/4/2022 would indicate that by using the word will, comma, the intention of the authority was clearly indicated to restrict the requirement, restrict the condition of nurses, of tutors, of teaching faculty to have the master's degree in nursing science to be applicable to only those persons whose age of superannuation would stand enhanced to 65 years. Full stop. The court does not find force in the argument of the learned counsel for the respondent that the requirement of having a master's degree in nursing would be mandatory, both for a tutor to be included as a member of the teaching faculty in terms of the resolution adopted by the Board of Governors, and the same, in the opinion of this court, is to be restricted only for the purposes of allowing an incumbent to serve up to the age of 65 years. Full stop. To the understanding of this court, comma, all tutors who were serving in the institute were intended to be included within the were intended to be included as member of teaching faculty in addition to the post already defined in terms of provision 2(5) of the bylaws of refunds. Has any amendment been made to the bylaws following this?
I'm not sure.
It's
Lordship,
6th of
but-
March 2024. To include it in the bylaws,
Yes.
the bylaws have to be amended.
Exactly.
Now,
May not be done yet, madam.
when the intention is to include all tutors, no, to include tutors in repans in the and not in the as member of teaching faculty, comma, the the application of the requirement of the incumbent to have an MSc in nursing would act as an impediment to all tutors serving in the institute who do not carry such a master's degree. Full stop. The resolution adopted or the letter dated 25/4/2022 do not indicate the intent to exclude any don't say do not intend, say expresses the intention to include the post of tutor into the definition of members of faculty, and therefore the interpretations sought to be given by the institute to restrict it only to those persons who already carried a master's degree in nursing science cannot be accepted by this court. What else was there? In view of the above, this court is of the considered opinion that the with the inclusion of tutors as teaching faculty, tutors of repans as teaching members of teaching faculty would apply to the petitioner also, thereby making him to be entitled to the enhancement of age of superannuation granted by the resolutions of the 22nd Executive Council meeting held on 3/1/2006, and as such the petitioner would be required to superannuate from service only upon attaining the age of 62 years on 34/2026. Full stop. Accordingly, this writ petition is allowed. The orders dated so those three orders are set aside and quashed. The petitioner is held entitled to serve the institute up to the age of his attaining superannuation, that is on 34/2026. Stop. The Learned Senior Council has submitted that given the short time remaining, it may not be possible for the petitioner to rejoin. It may not be practicable to direct a reinstatement as of today and require the petitioner to join his services. Stop. However, he submits that the petitioner should be held to be entitled to all the consequential benefits on setting aside of the order of retirement imposed on him, holding him entitled to the actual pay and all other benefits that may have accrued to him had he been allowed to serve up to the age of 62 years. Full stop. As a consequence of the setting aside of the retirement of the petitioner imposed upon him by the order dated imposed upon him with effect from 34/2024, the petitioner is also held to be entitled to the back wages and salaries for the period from 34/2024, not 34, 1/5/2024 to the date of his actual retirement. Date of his actual retirement. The pensionary benefits of the petitioners shall be calculated by deeming his date of retirement to be 30th of April 2026.
Pensionary benefits, if any, Lordship. It may not be there.
We had taken note of that submission, but there is something here which may require, yeah, if any, pensionary benefits, if any. We put on. There is one thing here. That is what we saw when we were going through. Just a minute. Page 58, number 9.
Yes.
See, 9.1 talks about pension fund. 9.3 talks of a gratuity scheme as offered by the CCS pension rules. Is it?
Yes.
If any. If we don't say, if any. What else? What else is it? We have to buffer it up.
I think it has
And
covered.
this is the basic outline of what we are going to
Yes.
decide. We'll try to have it signed and delivered today. Yes. Otherwise, you would have it by next week. No other submission to be recorded.
No other submission, madam.
Briefly applies.
We'll have to work on that
Yes.
last part of how we bring that. It will not be applicable part. We'll have to work on that other things. Anyway, this petition is disposed of. Huh?
Much obliged, madam.
No other matter. Don't give them as leftovers, you give them as a list again only. We come and see. 27? 27. List again. Anybody wants an earlier date? Fix it. Thank you.